morning, BADM 307 students. Your professor is in a fantastic mood today. Last night was a spectacular night for stargazing. I'm an amateur astronomer, so I put up my scope. First thing that happened was I visually watched the International Space Station go across the sky. Then I was looking at some various things, and I glanced over at the northwestern sky, and there was Comet Neowise. We're not going to see it again for another 4,000 to 6,000 years, but it was spectacular. You could see the comet and the tail. It was marvelous. I went in and got my binoculars, and it was even better through the binoculars. Then I looked at some what we call deep sky fuzzies. Nebulas that are very, very faint. And I finished off the evening using my lab cam and my iPhone, and I took a picture of Jupiter and managed to get 4 of the moons, although you can only see 3, but 2 of them are so close together they appeared to be 1. So I had a wonderful, wonderful evening. Woke up this morning to another beautiful sunny day in the Sunshine Coast. So here we go. We are going to do Chapter 7, and that is on sole proprietorships and partnerships. You will have at this point looked at the video from Chapter 9 on intellectual property. And interestingly enough, that ends with a discussion of the concept of the fiduciary duty, which crops up in the law all the time. For example, in insurance, you have a fiduciary duty to tell the insurance company anything that associates to the risk of the object that you want to insure. Intellectual property is on slide 71, and it relates to the fiduciary duty that an employee owes to an employer if the employee is a manager, and the idea is if you leave the employment of your business, you cannot take with you proprietary information that belongs to that business. Now, employees that are not managerial have no fiduciary duty in this regard, and so you get them to file or sign a confidentiality agreement as part of their employment contract. But a manager owes a fiduciary duty. So in other words, you can't say, well, I didn't sign an NDA, so I'm going to obviously be able to take proprietary information with me. No, you can't. And this concept of fiduciary duty will come up in the next couple of lectures, because not so much with sole proprietorships and partnerships, but when we get into corporations, you'll see that directors and officers of the company owe a fiduciary duty to the business. Okay, so we start off Chapter 7, sole proprietorships and partnerships, by first of all just talking about the various forms of business organization. So there are sole proprietorships, partnerships, various different types of partnerships, and then we get into corporations. Those are the 3 basics: sole proprietorship, partnership, and corporation. There are some other entities which look like business organizations, but they're not. They may support business operations, but they aren't actual in the business of making a profit for their shareholders. Is the easiest way to look at it. So on screen 72, you see the 3 forms of business organization, and then other types of legal entities below that are societies or non-profit corporations and cooperatives. A society is incorporated just as you would incorporate a corporation. The only difference is that the society is not there to make a profit. Now, it may do work that generates revenue, and they may at the end of the year have a profit, but that profit does not get distributed to the members or shareholders as dividends or return on capital. Okay, if the if the money is going to be dispersed in any way, it cannot go to the shareholders or members. It must go to a charitable source. So in other words, you have a society like a chamber of commerce. So let's say there's two chambers of commerce very close together and they decide to amalgamate. So one of those is now going to be wound up. The money that's left over in their bank account has to be distributed to the St. Mary's Hospital or the BC Children's Hospital or the Cancer Society or something like that. The same thing with cooperatives. We'll see that. So I'm just going to talk about that now. The members of a cooperative do not get to divvy up the profits. Okay. I used the Chamber of Commerce is obviously one of the best examples of a society. The Board of Trade is a society, and all the chambers of commerce are societies. So you incorporate, you have members or shareholders, and I'm going to check that out and let you know which it is. Under the old Corporations Act, people that own shares used to be called members. When we updated our Corporations Act, we started calling them shareholders, which is the more common term now. And the federal government updated its not-for-profit corporations, which used to be under the Corporations Act. They now have a separate statute for that, and I don't know, I haven't really checked to see whether they call them members or shareholders. Probably shareholders. The BC Societies Act has been updated recently too, and so they may have changed the terminology to bring it more modern. I'll check into that and let you know. Okay, so the Chamber of Commerce is formed, and it receives revenue from memberships and donations, and it puts on seminars, and it has meetings, and it encourages the government to do things in their locale. So that's their activity. It isn't a business per se, but it supports businesses. And as I said, they may have a profit at the end of the year, but they cannot distribute that. They must then use it for the following year. Other types of societies, you have the charities. Obviously, the St. Mary's Hospital Foundation is an incorporated society, and it raises money which it can then give to the St. Mary's Hospital on the Sunshine Coast. Same thing in North Vancouver or in Vancouver with the BC Children's Hospital and things like that. Another example, and this is one that you should probably be cognizant of as you go through your business career, because at certain points in time you may be asked to join a society that has a charitable objective, and you feel that not compelled, but you feel that this might be an opportunity for you to give something back. Well, I was asked to join a society. It was the First Night Celebration Society. When the century turned from 1999 to 2000, they had celebrations all around the world, the Happy New Year celebrations. Well, the First Night Celebration Society is a franchise out of the United States, which puts on non-alcoholic family-related activities on New Year's Eve. Well, it was going to be a big deal for the turn of the century, and not only that, but they were going to follow the different time zones, and they were going to televise the First Night Celebration Society's events. So one of my clients, a really sort of cutting-edge advertising agency, decided that they were going to get the franchise for Vancouver for the First Night Celebration Society, which they did. So they formed this society, and then they wanted some people on the board of directors. So they got marketers, and they got finance people, and they got advertising people, and event management people, and they asked me to join as a lawyer. And I thought, okay, this is a nice sort of charitable activity to give something back to the community, and I don't mind giving my time, but I didn't want to give them my house and my car and my cottage and my sailboat if for some reason the whole thing turned out to be a disaster and we got sued. So we had the first board meeting, and I knew I wasn't there because I was, really well known in the community. I was there because my client figured that he would be able to get free legal advice, and that's what I did, and I was more than happy to do that. At the first directors meeting, though, I said, okay, do we have two types of insurance? One was event cancellation insurance, in case at some point we had to cancel the whole thing and we'd already raised some money and then paid out the money. What do you do, right? You have a whole bunch of people that you owe money to. Well, event cancellation insurance will help with that. The other thing, and the more important thing, was I asked if they had errors and omission insurance. Okay, errors and omission insurance protects directors and officers in operations where the society or the corporation gets sued, and the directors and officers get sued along with it. And we did. Just to flesh out the story, the First Night Celebration Society in Seattle had more money, and they were going to put on an event at the Space Needle and shoot off fireworks and everything. And so they were designated the spot that was going to be on TV for the year 2000 as it came in. And so we were a little disappointed, but we lucked out in a way. Seattle had a bomb threat from a terrorist group, and so they canceled their event, and hopefully they had cancellation insurance. And of course that meant that we were in the only other franchise in this time zone, and so we became the televised event. That's good news on one side and bad news on the other, because if you're a terrorist and you were going to bomb the Space Needle and that's all shut down, so there's no point in bombing it, where's the next available event? Well, 3 hours, north. So we were really concerned that there might be a possibility of a bomb threat. So we checked into the event cancellation insurance, but as things turned out, we did not receive a threat. We were, very worried, so we had to spend more money on security. And we also checked again into the event cancellation insurance, but nothing happened, and we had the event. 16,000 people came down to the area around the Science World in Vancouver, and it was a very good event. We had some fireworks too, and we were on TV, which was fun. But again, the whole point is that it's a society, and you do that so that there is this concept of limited liability, which we'll get into later on. And in the back of your mind, you want two things: event cancellation insurance and errors and omission insurance. Errors and omission insurance will prevent, if the directors have to make a judgment call, then the errors and omission insurance will protect the directors and officers. That happened with the Sunshine Coast Gibsons and Sunshine Coast Chamber of Commerce. I moved up to the coast in 2004, and I was asked to join the Chamber of Commerce and become a director. And I thought, whoa, my reputation has preceded me. Well, no, I was new on the coast and I didn't know the problems they were having, and so local lawyers, I guess, declined them, and I joined and became a director, only to find out that the Chamber of Commerce had been sued. Now, I wasn't worried because it was sued for something that happened before I became a director, so I would have no liability in that, but they needed legal advice. And the very first thing, not only was the Chamber of Commerce sued, but the directors and officers were sued. And so the former president and secretary and the directors were really concerned that they might have some liability here because the Chamber of Commerce did not have any money to pay the damages. They were two frivolous lawsuits. I managed to get one dismissed at the settlement hearing in the small claims court beforehand, and then the other one went to trial. And clearly the judge said that the Chamber of Commerce would be liable if there was liability but the directors and officers were not, because they had done their due diligence. They had made a judgment call about whether a project was going to work or not, spent some money, then they realized they couldn't complete it, canceled the project, and a couple of businesses that had made donations sued them. The judge said, no, had they been negligent, then they would be personally liable, and the Chamber of Commerce vicariously liable. But they had met, they had looked at the information that was available, they had made a decision, they made the decision properly, there was a vote, it was recorded, so they made a judgment call and then corrected it. The next board corrected it when they found out they couldn't complete the project. So the claim was dismissed. But the important thing here is that when I was meeting with them, I said, is there errors and omission insurance? And obviously every Chamber of Commerce has to have that, and yes, it's there. And I said, okay, so everybody go home, nobody worry about this, because if we lose, the Chamber of Commerce is vicariously liable to pay, so whatever money it has pays part of the damages, and then the rest of you who would have to have paid out of your pocket are protected by the errors and omission insurance. Okay, enough said about that. So that's societies and non-profit corporations. The other business entity is a cooperative. If anyone has gone across the prairies by train, and it's unlikely you have because it's incredibly expensive, unless you sit up in what they call the day coach, where there's just seats and they recline and you sleep at night, and it's very uncomfortable. I know because I used to work as a porter on the CPR to put myself through university. But anyway, had you gone across the prairies, you would see these grain elevators. And one of them one said United Grain Growers Association. That's a cooperative. And another one says co-op. Okay. Well, the buyers of grain used to beat up the farmers really badly, pay them very little, and then sell their grain to make breads and stuff at a much higher price, and they'd make a huge profit. An individual farmer could not negotiate, but the farmers got together and they formed co-ops. And those cooperatives would say, okay, we'll bargain collectively, which gives us more bargaining power, just like unions. And they also bought farm equipment so they could buy a lot and get discounts and deals. And then they would have stores, which then in turn sold those farm equipment to the farmers at a reasonable price. So these co-ops are there, and that's a good example of how they operate. A closer example, one that I'm more familiar with, is my Sylvan Learning client, previous client, which I had talked about earlier. In some respect, I think it was in risk management when I was talking about checking credentials of people. Yeah, that's what it was. Well, the Sylvan franchisor is in Baltimore, and it's a big organization. And so the franchisor said to all its franchisees around the United States and Canada, everybody has to do television advertising. Well, my client, who had, I think maximum of 4, probably just 3 at that time, 3 centers in Vancouver, could not afford to do television advertising. Just doing the TV ad was expensive, but then buying the TV time was just, he couldn't do it. So he very cleverly got all the Sylvan centers around Vancouver and Vancouver Island together and said, let's pool our money and let's do one ad and put it on TV, and then we can afford to do this. And they said, yeah, really good idea. And then my client called me up and said, how do we do it? And I said, you form a cooperative. That becomes the objective of the cooperative. And then you pool the money in the cooperative. And then I think they had 2. They had one for Vancouver Island and one for the Lower Mainland. And they decided to amalgamate them, and one of them had money left over, and they wanted to wind it up. They couldn't just amalgamate because certain franchisees didn't want to become part of the other, whatever. Blah, blah, blah. Anyway, the point is they wound up one and had money left over and they had to give it to a charity. Okay, so that's the 5 types of forms of business organization that we are going to talk about. And gosh, 5, there's a potential Part B exam question. I'm not sure how I'd word that one, but I could do it. Next slide. Sole proprietorships. Not going to say very much about that. It's the simplest form of business organization. This would be Peter Holden doing business as Peter Holden's Law Office. I get a business license. Oh, that's it. I start. And I could register my name with the provincial government. It gives me some protection in the name. And then I just begin operating. Yeah, it's one of the less expensive ways to commence business. It's also one of the most dangerous because you have unlimited liability. Okay, there is no distinction between the business assets and the owner's personal assets. So in other words, if the business goes under and it owes $85,000 and it has $12 in the bank, well, obviously it owes a lot of money. No, the business doesn't owe a lot of money. The owner owns a lot of money, and he's going to have to sell his house, his cottage, his car, or maybe a couple of children. I'm only kidding. To pay, okay, because there's no distinction between the business assets and the personal assets. You can, in certain circumstances, and I tell you right now, if you think about doing this as a business person, you want to get legal advice. You can transfer your assets to your spouse so that in the event that you are sued, you have no assets. The creditors get what's called a dry judgment. Okay, I'm writing that on the board, dry judgment. Which means they win, but there's no money at the end of the rainbow. You can transfer your assets to your spouse. I did that in 1983 when I was called to the bar. I walked across the stage at the courthouse downtown, and the Chief Justice of the Supreme Court handed me a scroll and said, he mumbles. And I was so, nervous and excited in my robes and everything that I really didn't know what he said. I think he said, "Congratulations, Mr. Holden, you're called to the bar." Called to the bar means I get to practice law. I came down off the stage and my wife ran up, "Oh, congratulations, sweetie." And I grabbed her and and she went, "Like, what's that for?" And I said, "Congratulations." And she said, "Why?" And I said, "From this day forward, you own all our assets. We buy a house, you buy it. We buy a car, no, you buy it. We buy a sailboat, no, you buy it. We buy a cottage, no, you buy it. We buy some shares in Starbucks, no, you buy it." Okay, so she owns everything. So we get sued. No, I get sued. Let's say I get a huge mistake and I get sued for $5 million. Well, I have $1 million of liability insurance, which I have to practice law. That's what the creditors will get. $1 million. The other $4 million, they will not get it. They're owed it. Yes, I owe it. Yes, I know, but they will not get it. I don't have the money, okay? They'll sue my wife because I drive this car and I live in this house. No, they can't. She legally owns those. I own nothing, okay? So they could garnish my wages and stuff like that. But I would declare bankruptcy, and you can be released from bankruptcy within 6 months. I would be released from bankruptcy, and you get none of that $4 million. Okay, so and one of the things lawyers do when somebody comes in and says, "I want to sue so and so or this corporation or whatever," is they carefully look to see if there are any assets worth going after, because it's expensive to sue, and you wind up with a dry judgment. What's going through your mind, or should be going through your mind, is, okay, if my wife owns all the assets, what happens if she runs off with the mailman? Well, that isn't going to happen. I mean, I'm much more handsome than the mailman. Just kidding. And besides, it's a male woman. Anyway, the it sounds like she could take off and she owns everything and I would be left with nothing. But I'm protected by the Family Law Act. Now, the Family Law Act was not passed for this purpose. It was passed to protect the weaker person in a marriage. Most often, the man owned everything. The man had the bank account. The man bought the house. The man has the car in his name. And so the man runs off with his blonde secretary, and the wife has nothing, and it makes it really hard for the wife to even sue the husband because she has no money for a retainer to hire a lawyer. So they passed the Family Law Relations Act, as it used to be called. Now it's just the Family Law Act. And in there it says all the assets of the marriage are deemed to be owned equally. Okay. Now that means all the assets are in my wife's name legally, and I have a beneficial interest in it. So the only way I can get those back is if she voluntarily gave me half, or I sued her for half under the Family Law Act. Now, if I get sued and she leaves me, I sue her and I get my half back just in time to give it to my creditors. But if the relationship is stable, and you have to think about that in advance, then this is one sort of risk management thing you can do. Now, you cannot transfer your assets to your children, okay? And the reason for that is the Family Relations Act is there to protect the spousal relationship, okay? So if I gave my assets to my kids, put the house in my daughter's names, and they said, well, goodbye, Dad, get out, this is our house, I would not be able to sue them and get it back. So you can only do that between a husband and wife. All right. And again, out of abundance of caution, I'm going to say if you try to do this, then you'd better get legal advice because the courts are really looking at it. And there are a couple of statutes called the Fraudulent Conveyance Act and the Fraudulent Preferences Act, which you don't have to know for the course, but those allow such relationships to be attacked. One way is if I'm in my office and I'm working and I go open a file and I go, oh my gosh, I made a mistake. Oh my goodness, I'm going to be sued. Oh, hey, guess what, dear? You own all the assets. And I immediately transfer all my assets to my spouse. Well, the problem with that is that would be a fraudulent conveyance because I've done that for the purposes of defeating a creditor of whom I am aware. Well, in 1983, I was not aware of any creditors because I didn't have any clients and I didn't have any, files. So I was doing it for estate planning purposes. And my legal career is over after 33 years, and I did not have any problems in that regard. But if I did now, they would never be able to say I did that transfer in 1983 for the purposes of defeating this creditor that I just found out about. Okay, so, but there are ways that you can be attacked, so you have to get legal advice. Okay, that brings us to partnerships. Partnership is defined as Section 2 of the in Partnership Act as two or more people working in concert with a view to profit. Hold on one sec. Yeah. Sorry, I thought I heard a knock on the door. In this package of material, on approximately page 28, and the reason I say approximately is I have not gone into the university to set up the material for this year. This is an old version. I have the Business Corporations Act, and on page 32 I have the Partnership Act, just the sections that we refer to in the course. Okay, so I would highly recommend that you buy that package. Now, some people don't even buy the textbook. Oh, what do I need a textbook for? Well, I don't have to buy that. It's optional. Okay, so let's be a boxer. Okay, tie one hand behind your back and then go in the ring. All right, that's what you're doing. If you don't buy these materials, then it's like a hockey player that wants to play hockey without a hockey stick. It's like a soccer player that wants to play soccer without a ball. You're putting yourself at a disadvantage. You'll have that. I was going to say you have that to bring into the exam with you, but it's an open book exam, so you do have that. See, think about it. The Partnership Act is online. I could just go in and Google during the exam. There's the Partnership Act. Well, it's about 300 sections long. Okay, so during the exam, you're going to sit there and scroll through the sections. There's the one I need. Okay, Corporations Act. Let's see. There's about 450 sections. So let's scroll through, and oh, there's the one I need. So you can bring those in and you'll be able to reference the material quicker. All right, there was a knock at the door. My daughter needs a ride somewhere. Again, one of those COVID-19 working at home things. So I'll put this on hold and I'll come back and pick it up later. All right, there's been a change in the weather. It doesn't look like I'll be seeing the comet tonight, but it's still dry outside, which is what counts, because I have to take another break later on and mow the lawn, but hopefully that'll be after I finish the partnerships. Okay, so I was talking about using the statutory material in the exam. You should familiarize yourself with it, and when I do the review for the exam, I'll talk about the sections that you should really take a look at. Advantages of a partnership, obviously, a pooling of wisdom and knowledge. Two heads are better than one. I know some legal stuff. You know some property development stuff. Well, together we could do a property development business, because my law expertise would go with your property development expertise. Financing. Obviously, I've got some money and you've got some money, so together we've got more money to start a business than I would have alone or you would have alone. And then there's simplicity and ease. I've already talked about that with respect to sole proprietorships. Starting a partnership, you just register your partnership name in Victoria and bingo, bango, bong, open up a bank account, and you're off and running. Potential for growth, well, yeah, I suppose because there's a pooling of wisdom and knowledge and finance and assets and things like that. There's a greater potential for growth. So I don't think it's really a separate advantage. I think it's part and parcel of those two first elements. And the potential for growth has so many other factors involved in it that I put a big X beside it, because I don't really believe in it. But it was in a lot of the material that I read, so I've included it. Okay, disadvantages. The disadvantages outweigh the advantages big time. You have to realize that this is Peter Holden speaking from a position of a bit of a bias here. I was in a three-man partnership. I'm really glad I did it, because I can say I've done it, but it wasn't the be-all and end-all. It wasn't the pyramid of the legal career that a lot of lawyers think it's going to be. It did not end particularly well. I didn't lose any money. I made money, but it was not the success it should have been. And we'll get into the reasons for that as we work through the disadvantages. The biggest disadvantage, and it makes partnerships even worse than sole proprietorships, is the concept of joint liability and joint and several liability. Okay, joint liability. The partners are all responsible for the debts and obligations of the business. Okay, that's fine. That may be a little bit better than a sole proprietorship where you're responsible for the debts and obligations yourself. But when you get to the joint and several liability, joint liability is outlined in Section 11. Joint and several liability is in Section 13. This is where partnerships are even more dangerous than sole proprietorships, because in a sole proprietorship, I don't want to be negligent. I don't want to get sued. I don't want to have a problem. But these things happen, okay? At least in a sole proprietorship, I have control of that. Okay, if I make a mistake, all right. Hopefully I'm a big enough person that I can pay for my mistake. But in a partnership, because you're jointly and severally liable, let's say there's three partners, as there was in my law firm, and I have assets, but the other two partners have managed to transfer their assets to their spouse. One of those other two is negligent, and causes a loss, well, he has no assets to pay for it. Okay, the other partner, she doesn't have any assets to pay for it. Well, I wasn't negligent, so, why should I pay? Because I'm jointly and severally liable. I'm jointly liable with the other two, but I'm severally liable for the amount. Okay, so I have to pay the full amount. And that means I could actually wind up paying for someone else's mistake. And that makes partnerships a little bit more dangerous than sole proprietorships. I don't have any control over that other partner, really. The need for group decisions means a loss of valuable time. We had a 3-man partnership, and I'm not being sexist, it was 3 men. A three-person partnership, to be politically correct. The 3 of us couldn't get together for any length of time to do strategic planning because we would always be interrupted by a client that needed work done immediately, if not sooner. We finally had to take a Friday off, close down the law firm, go over to Victoria, go into a hotel, leave the computers, leave the cell phones, and not tell our staff where we were going, so that we were isolated for 3 days to do some strategic planning. Unfortunately, the strategic plan failed. That's another story. Stalemates may lead to ineffective activity. This is an absolute disadvantage, and it's the one that I have personal knowledge of. In our 3-person partnership, we had the 3 lawyers, 2 legal secretaries, a receptionist, and then we had this person that was a manager. Okay, it had and she managed our law firm, and she had all sorts of great credentials, just none of them was in management, all right? She got the job because she was the wife of the senior partner's best friend, and his best friend's wife needed a job, so he hired her. I was unaware of this when I became a partner because the other 2 were operating already. This became a real bone of contention for us because I kept saying, she's totally incompetent. We have to fire her. We were losing money. You do file, and you have the bill, the last thing in the file, and then you have the disbursement receipts, all the things that you spent money on, and you generally attach the disbursement receipts to the bill, and then you put the file away. Well, something that would happen routinely is a client would phone up and they'd say, Peter, on your last bill, which I'm about to pay, and it was like 7 months ago, there was this disbursement, for $180. What is that? Well, I can barely remember the client, let alone the bill, let alone the receipt. So I would say, well, I'll get back to you. And I would contact the manager, and I'd say, okay, I need the such and such file, the receipt for $180 attached to the bill and the such and such file. We routinely couldn't find the receipts because I don't know whether she threw them out or whatever. And quite often we couldn't even find the file. And so I get to phone the client back. Oh, I don't know what it was, but I'm sure it was legitimate. You can't do that. So you had to say, just pay the bill and not the $180. And we'd be losing money. So finally, I'd had enough, and I dragged the other partner into the senior partner's office, and I said, okay, this is not going to take long. I want to vote to fire her. So we had a vote. I vote to fire her. Senior partner says, I cannot fire her. She's the wife of my best friend. And the 2 of us look at the 3rd lawyer, who goes, I don't know. And he runs out of the room. And I thought, oh, great. I'm in partnership with a lawyer who's got to be the only lawyer on the face of the planet Earth that does not thrive on controversy. Okay? Eventually he actually retired from the practice of law because he didn't like conflict. That's all lawyers do, is work out conflicts. Anyway, 1 vote for, 1 vote against, and an abstention, which means it's a tie, which means ineffective activity, and we struggled on until the partnership came to an end. It's more difficult to change ownership in the sense that there's 2 of you and you have to agree, if you don't have a partnership agreement, to some mechanism for one partner to leave, or for the sale of the partnership as a whole. Potential liability after dissolution is is a bit of a problem, because if there's three partners and you break up and there's somebody dealing with one of the partners that does not realize that there was a breakup, and that former partner is negligent, that client is going to sue that partner, and he's going to sue the other two partners. And you'll say, but the partnership came to an end. And there will be this thing called warranty of authority, which suggests that unless he knew the partnership was over, he's entitled to sue you. So there's potential liability after dissolution. Okay, there are limited liability partnerships. Limited partnerships. So there's, the three of us, for example, and we need additional financing. We find somebody that wants to invest in the partnership. They do not want to have the joint and several liability, so they say, well, I'll be a limited partner. I'll invest the money. If the partnership, goes under, I lose my investment, but my investment ends there. This is in Section 50 of the Partnership Act. The only caveat on this is in Section 64, it says if that limited partner gets involved in management in any way, then they lose their limited liability status and they become jointly and jointly several liable with the general partners. There are limited liability partnerships, and this is a relatively new concept. I think British Columbia was the last jurisdiction in North America, north of Mexico, to institute a statute amendment to allow this. What it means is, in our partnership, for example, I am no longer liable if one of the other partners is negligent. He is personally liable, and the liability doesn't go to the other partners, which sounds great, and it is to a certain extent. It means I'm not liable for the senior partner or the other partner's liability. However, we had two legal secretaries and a receptionist. If one of the legal secretaries makes a mistake and is negligent, the three of us are jointly and severally liable for that negligence, because we're vicariously liable for the mistakes of our employees. In a larger partnership, this becomes really important. Let's say there's 7 partners and there's 18 associates. If any of those associates make a mistake, or just about everybody has a legal secretary or a legal assistant, and so you've got another 18 people. If any of those 36 people are negligent, then again, that won't protect you. Don't worry about contractual joint ventures or equity joint ventures. If you read the textbook, you'll find out what those are about. But joint venture, I just want to explain. Let's say I'm a lawyer. I am a lawyer, and I have some clients, and I do some work. And then over here, there's a bank person, and then there's a real estate agent, and then there's a property development, and then there's a lot for sale. Well, the 4 of us get together, and the banker can raise funds, not through his bank, perhaps, or maybe he could, and the real estate agent can buy and sell the lot, and the developer will build a house on it, and I'll do all the legal work. And so we want to form a partnership. But the banker, for example, will be loath to be responsible for any negligence I have in my law firm. So I'm not negligent on this project, okay? I'm negligent somewhere else, but if they are in partnership with me, then they become jointly and severally liable. Well, you can set up a joint venture agreement, and you have to have it in writing to be effective, but it's for that one project only. So if one of us is negligent on that project, then the rest of us are jointly and severally liable for that negligence. But if I'm negligent on a file that doesn't relate to that, then that's excluded, because the liability is reduced just to that one venture. The difference is my law firm was supposed to go on forever and ever and ever and ever. It didn't, but it was supposed to, and so that's a general partnership. But this is a partnership for one venture, and after which it's closed down. And so this joint venture can be set up as such to reduce exposure to liability. All right, that brings us to the end of Chapter 7, and rather than stop here, I'm just going to continue on the same video. and we'll do Chapter 8, which deals with corporations as well. A corporation is a separate legal entity created by statute, and it is separate from the shareholders, directors, and officers. Because of that, it becomes an extremely effective risk management tool to shift risk away from those shareholders, directors, and officers to a separate corporation. Corporation versus company. You have to be a little careful here. Under statutes, when corporations are made now, they have to end in LTD, Anchor Corp, or Limited, Incorporated, or a corporation. Not so in the past. So, for example, when the Hudson's Bay Company, which is a corporation, was formed, we did not have a statute which said that you're going to create a separate legal entity. The way the person formed the Hudson's Bay Company was in 1640, he went in to see the King of England, okay, and he said, I want to be formed into a corporation. The reason being is he was going to do the fur trade in Canada, and he was going to have thousands of investors. Well, if you have a partnership and you have thousands of partners, chaos. So he said, I want to form a new type of business called a company where there are lots of members, they didn't know about shareholders then, who invest, and they elect a small group of people who run the company called the directors. And then the directors appoint officers, and bingo bango, you're away. And the king said, well, sure, that sounds fine. What do you want it to be called? And he said, I want it to be called the Company of Adventurers and Explorers. And he said, thou art a corporation. Or didn't call it a corporation. Thou art a company. Okay. And he created the company. If you could get in to see the Queen's representative in the province of British Columbia and say to the lieutenant governor, I want to be formed into a corporation, the lieutenant governor could say, thou art one. Okay. This is still done not for business purposes because we now have the BC Business Corporations Act to do that. But for example, when Capilano University was created from Capilano College, as it then was, the lieutenant governor said, thou art a university. And you can actually see that declaration by the lieutenant governor on a plaque as you enter the Birch building, if we ever get to go back on campus, and you're about to go down the stairs from the second floor to the cafeteria area. On the right-hand wall, there's a nice, beautifully presented plaque that says Capilano University was created. Okay, so we have this thing called companies, which may or may not be a corporation. Hudson's Bay Company obviously is, but you could find ABC Manufacturing Company in Richmond, for example, and it may not be a corporation. It probably isn't, because how did they not end in LTD Anchor Corp, right? I had a client who wanted to use a trade name, and he called me up and he said, I need a search done, and I gave him a quote for doing a trademark search and a trade name search. And he said, oh, okay, great. And he sent me a retainer in the mail, and I opened the telephone directory. We used to have them back then. And there in Richmond was a business with exactly the same name ending in company. And so I called my client back and said, no can do. He said, wow, that was really fast. And I said, well, I opened up the telephone directory, and there it was in Richmond. And there was a long pause, and he said, are you going to charge me all those legal fees for doing that? And I said, no, Francis, I tell you what, go back and choose another name. You check the white pages, you check the yellow pages, you go online and just, type it into the search bar. And then if nothing comes up, then contact me. I'll check the corporate registry and the trade names registry, and I'll check the trademarks registry in Ottawa. So you have to be careful about corporation versus company. Private corporation, public corporation. Private corporation is what you and I will probably wind up using. if we did business in a corporate sense, because we can do that ourselves. Public corporation, these are the big boys, and it's a rough and tumble market. You have to have about $500,000 to $600,000 in seed capital to get listed on the stock exchange and do an initial public offering. Okay, so you have to have money to make money, and it's extremely dangerous. In the past, what used to have happen is you wanted to be listed on the stock exchange. Along would come some promoters, and they'd have the money, and so they would initially list. They would take shares, they would sell their shares and get their money back plus a profit out, and then you were left with the public company plus whatever money you made on the stock offering. Quite often what would happen is they would do it for you really quickly. It would be listed on the stock exchange, the shares would start to sell, they would blow out their shares, no one would buy shares, and those that had them would sell them quickly because they don't know what's going on, and you're left with a huge debt and a publicly listed company that is inoperative. So you have to be careful there. But a private corporation has to have less than 50 members, so you can have 49 shareholders. Usually there's anywhere from 1 to 5 or 6, usually around 2 or 3. Public corporations, no limit on the number of shareholders, and private corporation, the sale of shares has to be restricted in some way. The usual way is in the articles for the company, and we'll talk about those in a little while. The articles of the company are the day-to-day operating instructions, how shares are issued, how meetings of the shareholders are held, how meetings of the directors are held, how officers are appointed, where the records are kept, all those sorts of things. And in there, usually the last paragraph or second to last paragraph says that the shares may be sold only with the consent of the directors. And that's sufficient to restrict the sale of shares. And that's also dangerous, and I'll come back and talk about that in a few minutes. So that's the difference between a private corporation and a public corporation. Shareholders versus members. I think most jurisdictions in Canada have now updated their statutes related to the formation of corporations and now call them shareholders. BC used to have a Company Act, and they were called members, straight from 1640. But now we have the BC Business Corporations Act, and we now use the modern term shareholders. Shares versus stock. No magic here. Shares and stock are exactly the same thing. Shares is generally used in Canada. Stock is generally used in the United States. Stock is now, of course, becoming more and more used in Canada because we just admire those Americans so much. We want to just be like them. I'm being a little facetious, but it's just, the power of the American economy makes us change. Federal versus provincial jurisdiction. If you form a corporation, you have to decide under which jurisdiction you are going to form the company. If it's a business that is monitored or controlled or regulated by the federal government, like an airline, an insurance company, a railway, a seagoing shipping line, a bank, those are all regulated federally, and so you have to incorporate under the Federal Business Corporations Act. A few years ago, I had 2 students in my BADM 107 class that came up to see me after class, and they said, Professor Holden, will you look at our incorporation documents? The 2 of them and their fathers, the 4 of them were going to form a business which was going to be a franchisor, and it was going to be the next McDonald's. They were sure that it was going to be just, fantastic. It was going to be called Tons of Tofu. No, I'm only kidding. I don't even know where they're at with their progress, so I cannot actually say the name, but they had incorporation documents under the federal Federal Business Corporations Act. And I said, why do you want to do that? And they said, well, we want to do business in all of Canada. And I said, but where's your head office going to be? And they said, well, it's going to be in Vancouver. And I said, well, if you incorporate federally, you're going to have to extra provincially incorporate in BC to do business in BC. And so you're going to do 2 incorporations. And they said, but we want to operate in all the provinces. And I said, are you going to have an office in every province? And they said, well, we're going to have franchisees all over the place. And I said, yeah, okay, but you have your office in British Columbia and you have a franchise agreement with somebody in Manitoba, then, you incorporate here, but you're not going to incorporate there. The franchisee is going to incorporate there. And so they wound up incorporating in the province of British Columbia. Pretty much the same cost. It's just that they would have had double the hit had they done it federally first. Okay, so most businesses, other than those regulated by the Canadian government, can be incorporated in the provinces. And there's different incorporation methods, which we do not have to get into in this course. The next slide is slide 78, and it is the most important one on this topic because we're starting to get into the advantages of a corporation. And the big advantage, the one that is most critical and the one that makes it a risk management tool, is limited liability. Strike that. The jury will disregard that last comment. It's not unlimited. It's limited liability. Okay, so the diagram on slide 78 shows a corporation. There are, in that particular diagram, 4 shareholders. There could be 2, there could be 1, there could be, 48. And those shareholders are protected from liability by 2 sections of the BC Business Corporations Act. Section 30 makes that corporation a separate legal entity from the shareholders, from the directors, and from the officers. Section 87, and I have to remember to change that because that screen says 86 for some reason. It's Section 87. It's in the statutory material, and what it says is the shareholders are not responsible for the debts and obligations of the corporation other than the value of their shares. So I invest $5,000 in Starbucks. If Starbucks had a bad shipment of coffee and wound up poisoning 42,000 people and had this huge lawsuit, nobody's going to knock on my door and say, Peter Holden, you own 1,000 shares in Starbucks. Your proportionate share of that lawsuit is this amount. I lose whatever I've invested, okay, but I would not lose any more. That was the whole design of the private corporation, so to try to encourage people to invest, knowing that they could lose their investment, but the loss would be stopped there. Well, that's fine, except that for public corporation, that works. Starbucks, Exxon, Microsoft, you invest, right? For a private corporation, though, if we were protected as shareholders but not as directors and officers, then there would be almost no advantage because the directors and officers are generally the shareholders in private corporations. So you have a situation where you want the protection, but it doesn't come from the statute. It comes from common law. And so on the diagram, you see that the shareholders elect the directors appoint the officers, and then off to the right-hand side, it says agency law. Well, it's agency law that protects the directors and officers. So between the shareholders, directors, and officers, there's this fictitious barrier, which a judge in the late 1800s in the United Kingdom coined as the corporate veil. Okay, and a lot of people are prevented from suing either the shareholders, directors, or officers because they cannot pierce the corporate veil. And so obviously the shareholders get statutory protection. The directors and officers protection comes from agency law. But what that means is the directors and officers must do their due diligence in order to be awarded the protection. And I saw you should have recognized that in the Chamber of Commerce scenario that I talked about. The Chamber of Commerce was sued, as were the directors and officers. In court, the judge was very specific when she said that the directors and officers had done their due diligence. I'll see if I've got a copy of that case, and I'll try to put it up on Moodle. So they have to do their due diligence, and the due diligence just means you have to run the corporation as a prudent business person would. Okay, and this is really specified in Section 142 of the BC Business Corporations Act. And I'm just going to see if, in fact, I've given that section next. No, on the next slide, I give you Section 30 and Section 87 so that you can read them. And I don't get down to Section 142 until slide 88. And hey, there's that word, fiduciary duty. Directors and officers owe a fiduciary duty to the company, and they must exercise the care, diligence, and and skill of a reasonably prudent person, okay, in similar circumstances. So if you do your due diligence, then you're okay. If you don't do the due diligence, then the corporate veil can be pierced. Let's look at this. Back to the Sylvan Learning Center example I gave you. The manager of that business would be one of the officers of the corporation, which would be protected by the agency law as long as she did her due diligence. She hires the instructor and does not do the records check, and it turns out he's a pedophile. The corporate veil can be pierced, and the directors and officers can be held liable because the president and secretary of the company hired that manager, and obviously if they hired somebody that's incompetent, then they haven't done their due diligence. Okay, so that's what we're talking about. All right, so on slide 80. We look at the other advantages of a corporation over a partnership, which means obviously over a sole proprietorship as well. There's a separation of ownership and management. My wife, for example, owns a few shares, like just for fun, in the Bank of Nova Scotia and the Toronto Dominion Bank. What's my wife know about running a bank? Nothing. Okay, very little. But she does know that the directors of those banks know what they're doing. Those fellows are making, ladies and gentlemen, are making money hand over fist. Your money. So she invests there because there's a separation of ownership and management. Okay? Continued existence. Corporations do not die with the shareholders. I will make you a $20 bet right now, okay, that not one of the natural shareholders of the Hudson's Bay Company is alive today. It was formed in 1640. There were shareholders. They've all died. Those shares get passed on to their heirs or beneficiaries. They die. Those shares get passed on to heirs and beneficiaries. But the corporation merely continues along, okay? That's a big advantage. I had to say natural shareholders because apparently there were some corporate trusts set up to hold shares. And the trusts, of course, are formed pursuant to statute, and those they've continued. So I had to be careful. Okay, no loyalty or duty of good faith on the shareholders. Now, wait a minute. I just said my wife owns shares in the TD Bank and the Bank of Nova Scotia. Oh my gosh, is that a conflict of interest? No, it isn't, because she doesn't run the company. Okay? And furthermore, there's no duty or loyalty on her part to those banks. Every year they have a annual general meeting. They have to by law, and it takes place in Toronto, where the head offices are. My wife owns, I don't know, let's say 100 shares. There are millions of shares out there. So she's not going to fly all the way back to Toronto to vote her 100 shares. I mean, the little bit of money she makes by way of a dividend wouldn't cover, the peanuts on the flight, let alone the cost of the flight, the hotel, meals and that sort of thing. So she does not have to go. Okay, there's no requirement in law that she do that. She doesn't have to vote if she goes. There's no requirement in law that she has to do that. And of course, therein lies a danger of corporations, private corporations, because they have to have annual general meetings too. And if you have a small group of shareholders and they decide not to turn up, then you have the problem that there may not be a quorum. So what you do in a situation like this is, this is what the big companies do as well. They send out the notice of the annual general meeting, and they send out a proxy. The proxy is provided for in the Business Corporations Act. And what the proxy does is it says, fill out the proxy, sign it, and give it to me, the secretary of the company, and I will vote the way you want to vote, or you can just give it to me and then I'll vote for you the way I want to vote. And they collect those proxies, and in effect, if nobody went back to Toronto, which is probably what's going to happen this year because of COVID-19, they can do one of two things. They could try to hold a very unruly meeting online, or they could just collect the proxies and the secretary can have a vote in his study at home in the evening with a glass of scotch and a cigar. Okay, and he can just vote using the proxies. Okay, no loyalty or duty of good faith. Possible tax advantages. I say possible tax advantages because you really have to get an accountant here. If you are a sole proprietor and you start making huge dollars, you're going to be paying about 65% of that in taxes. And the more you make, the more the government takes. So governments take. So what you can do is you can form what's called a Canadian controlled private corporation. When you start breaking the 60% tax bracket, and then you become a shareholder in that company, and then you pay yourself a salary and you can control that. You're a shareholder, you can pay yourself dividends. Why is that an advantage? Well, dividends are taxed at, I think it's 18%, but after the accountants get finished doing their smoke and mirrors magic, it's like effectively 14%. So you can substantially reduce what you pay in taxes by taking less salary and taking dividends. You can also leave money into the corporation, and when the business is finally, you decide to retire, there's two ways to do it. You can sell the corporation and then that money would go to the buyer, or you can keep the corporation and sell the assets. Now the corporation is there with money. So take out a little bit over 10 years, or 15 years, or whatever. And you can control your tax. You can't eliminate the tax, but you can control the amount you pay. I say these are possible ones. You have to. Our tax act is so incredibly complex that you really have to get an accountant to start doing that effectively. But there is a potential for tax benefit. Now, we're going to get into the reason why or how this concept of due diligence works. And the first and foremost way of making sure that you're doing your due diligence is to ensure that you're acting as an agent for the company. All right, and this is, oh, I'm sorry, I forgot slide 61, where it has the disadvantages of the corporations. Cost, if you incorporate a company and you get listed on the stock exchange, you have, huge costs. If you incorporate a private corporation and the costs are negligible. Now, the problem is that most people, when they're starting a business, budget for everything. And they go, my gosh, I'm running out of money quickly and I haven't even started yet. And then they go to their lawyer and they say, incorporate a company for me. And the lawyer says that'll be, something like $1,500 and then another $1,500 to $2,000 for a shareholders agreement. And the person cannot afford it. They should budget for that because those two things are as important as hydroelectric hookup to your office, okay? So the cost of incorporating a company and having a good shareholders agreement can be around $3,000, okay? In the scheme of setting up a business and $120,000 investment to begin with, $3,000 is not much, and it is really good insurance, okay? So the cost is not that much. Regulatory requirements. Oh, man, if you have a company listed on the stock exchange, you are up to here in regulatory requirements. You need a snorkel because you're below water. But if you have a private corporation, I can keep your company in good standing every year for $285. I used to do that for about 45 to 50 companies. Good standing. I'm writing it on the whiteboard. Okay, so that means you have to remember this for exam purposes. Good standing means you are up to date with your regulatory requirements with the provincial government. Okay, if you're incorporated provincially, which most of you will be. What that means is you've had your annual general meeting and you have a resolution of the directors members appointing the directors, and then a resolution of the directors appointing the officers. I do all that for about $285. I send it to my client. They sign it. They send it back to me. I file the annual report. Bingo, you're okay. The annual report and no requirement for financial statements to go to the government. So it's really not that onerous, okay? Then there's an inability to flow losses through. If I have a sole proprietorship and I have a loss, and I can manage to raise some money and start another business, and I start making money, I can use the losses from that first one to reduce my income on the second one for tax purposes. Why? Because it's all me, sole proprietor. Same thing in a partnership. In a corporation, though, if the corporation has a loss and I am the shareholder, I lose my investment, but I can't take that and say, oh, I'm going to reduce my taxable income using these losses. The losses are the corporation's, okay? So you think, oh, well, if I've got the corporation that's got a loss, I'll just, start up my next business using that corporation. You cannot do that because it owes money. You start up the new business, put money into it, and those creditors are going to want that money, okay? So you can't do that. So an inability to flow the losses through. And then the last one has a big X beside it, and make it bigger. Okay, on the screen, make it bigger. So many management textbooks and actually a couple of law textbooks says one of the biggest problems with a corporation is that because people are contracting with the corporation, they want the directors to give guarantees. So this is a tremendous disadvantage when compared with partnerships and sole proprietorships. Totally wrong. Okay? Why? If I have a sole proprietorship and I borrow money from the bank, they're not going to ask me for a personal guarantee. Why would they? They already have me primarily liable on the debt, right? They give me the money, I have to pay it back. Okay? In a partnership, the partnership borrows money. They're not going to ask for guarantees because the partnership isn't a separate legal entity. It doesn't owe the money, the partners do. So we have to pay it back. in a corporation, if the money is lent to the corporation, the bank knows that if the corporation goes insolvent, they cannot pierce the corporate veil and make the directors, officers, and shareholders liable. So they want guarantees. Why is that a disadvantage? I'm primarily liable as a sole proprietor. I'm liable as a owner of a corporation. So it's not a disadvantage. It's the same. So I put a big X beside it. You put it on the exam and say it's a disadvantage, you might get a half a mark. Okay. Due diligence. You have to act as the agent for a corporation. And here's why. I'm going to show you the next screen, which has the P, which is a principal, and the 3P, which is a customer, and then has A as the corporation president. And all that is the agency relationship, okay? Agency is defined, do I have it in here? No. All right, so you got to take notes. An agency relationship is one where the principal hires an agent to bring the principal into contracts with third parties. Okay? Let me describe a non-corporate agency relationship so you get a really good understanding, and then I'll show you how it equates to corporations. I had a student, his name was Vincent. He goes through our program, does the International Business Program. After he graduates, he comes into my office with a coffee and a donut, so already he's one of my favorite students. And he says, okay, Peter, I want to get into international business. I have no money. I have student debts. Is there a way I can do it? So between bites of the donut and sips of the coffee, I explained to him that he should just establish himself as an agent. So he makes up business cards and he puts his name on there, Vincent, agent. Okay, and then I said, go out and schmooze, go to Chamber of Commerce meetings, go to trade fairs, and hand out your cards. While this was going on, there was a nurse in the interior of BC who was working with Alzheimer's patients. And Alzheimer's is a terrible disease. You begin forgetting things. And, sorry, what was I saying? No, I'm not kidding. That's a bad joke. Eventually, it gets so bad that all of a sudden you have these blank moments. Where you cannot remember who you are, where you are, or why you are. I can't think of anything more frightening. Except maybe looking down the barrel of a gun. Anyway, that doesn't kill them. Okay, eventually Alzheimer's gets so bad that your brain forgets to tell your body to breathe and you die, but that's way down the road. At that moment when you suddenly have these black blanks, what kills you is the stress. Okay, you get so stressed that you have a heart attack. Okay, well, she likened these moments when you didn't know who you are, where you are, or why you are, to being a baby. Okay, little babies. They're there, they don't know who they are, they don't know where they are, and they don't know why they are. They begin crying, you give them a stuffy, and they go, oh. Okay. And so what she started doing was taking stuffies, and when an Alzheimer's patient had an episode, she would give them a stuffy, and they would hug the stuffy, and they would calm down until this episode passed. And she started saving lives, and doctors and nurses all around the province said, send us some of your dolls. Like, any doll wouldn't do? Anyway, they thought, they asked her for some of her dolls. Well, she made some for herself, but when she decided that she was going to make a lot of them because she could sell them and make money, she suddenly realized that they were very expensive to manufacture in the province of British Columbia because our wages are so high. So it was not going to be economical. So she figured out that you could make them less expensively, much so, in the Far East. And then she was a little confused that it seems that to go to the Far East, you actually head west. I'm being facetious. She didn't know how to go about going to China or Vietnam to have them made. And so she was at some event and she got one of Vince's cards. She hired him to go to Hong Kong and find some manufacturers for her dolls. Vince is back in my office with another cup of coffee and another donut, and now he's not my favorite student, he's my favorite graduate. He says, "Okay, Smarty, now you've got me as an agent. How do I do this?" And I said, "Vince, it's really easy. Your principal pays for your flight, your hotel, your travel, taxis and things, and your food. So get on a plane, fly to Hong Kong, get out of the plane, walk out of the airport. There's a taxi cab there. They all speak English. Say, take me to the Canadian Trade Commissioner's office. Go to the Trade Commissioner's office, walk in and say, I need these dolls made. The Trade Commissioner officer will take you to a couple of manufacturers. You choose one, you give them the doll, you enter into contract, and you're done." So I get a call from him, and he's in Hong Kong, and he's in the hotel, and he's in the bar, and he's schmoozing other people now, and he's doing it on his principal's dollar. Okay, he said, Peter, thank you very much. I'm an international agent. Well, look back at the diagram. Let's say this manufacturer in Hong Kong makes defective dolls. Who can the principal sue? Well, the customer is the person, the manufacturer who makes the dolls. She can sue him because she's got a contract with him. She cannot sue the agent because the agent is not connected. Okay? Let's say the third-party manufacturer sends the dolls, but the nurse doesn't pay for them. Who can the third-party manufacturer sue? Well, he can only sue the principal. So as long as you do your agency due diligence, in other words, you make sure that the manufacturer knows that you're acting as an agent for this principal, and you're bringing the principal into a contract with a third-party manufacturer, then you have no contractual obligation. You can only be sued for negligence or something like that. And you just, don't be negligent. So you have this wonderful job where you're getting costs and commissions, and you have no liability. Now make it a corporation where the principal is the corporation and you are the agent, president for the company, or an officer, or even a director. And what you do is you contact a third party and you enter the company into a contract with a third party. And if things go bad, then the third party cannot sue you. They can only sue the corporation. They cannot pierce the corporate veil and make you liable. All right? Now, how do you make sure that the person knows that you're acting as an agent for the company? In the book and in the chorus, I always use my Peak Performance Pontoons Inc. example. So you would set up the signature line as seen on screen 83. On behalf of would not be there. Okay, that's me putting that in to explain that if you have Peak Performance Pontoons Inc. per a line where you sign and then underneath authorized signatory, that per means you're signing on behalf of the corporation, not for yourself. That's your first line of defense. In the world according to Peter Holden, and I have been vindicated, and I'll come back to that, you should put below the line authorized signatory. Are you the authorized signatory for yourself? No. You are yourself, okay? So if you are an authorized signatory, it means you must be authorized to sign for someone else, all right? So all that is legally required is to have Peak Performance Pontoons Inc. or ABC Manufacturing Ltd. or whatever, per, and a line where you sign. I, for years, kept telling my clients, put authorized signatory down there, because what you're trying to do here is dodge a liability bullet. And you get into court and the judge goes, Benton Counter, you're trying not to be liable for your corporation, which you were running. And I don't like that. So the judge quite often wants to make the president or the director liable. So if you have per there, the judge cannot make you liable. Okay. My attitude is, why take a chance? Why not put authorized signatory down there too? Because it doesn't cost a lot in ink, and it's one more nail in the coffin that will prevent that judge from making you personally liable. I did that for years and years and years. And then the Law Society of BC had this continuing legal education seminar on contracts. And I had to do a certain amount of professional development for them and for the university every year. So I paid the money and I went to this, and they bring in a lawyer from Atlanta, Georgia, a really well-known contractual lawyer. And I thought, why did they bring her? Like, isn't there a competent lawyer in all of Canada, or gosh, maybe one or two in BC, that wouldn't cost as much to bring in? The Law Society likes to look, ooh. And so they paid this person to fly all the way up here. Anyway, halfway through, she was talking about signing, and she said, the corporate name per, and she said, and you should always as well do an extra step and put authorized signatory there. And I went, yes! And she looked at me and I said, oh, sorry, I've been telling my clients to do that for years, and I just feel vindicated. Okay, but you should do it. When you get checks made by the bank, they will put signature lines down and they'll put authorized signatory below it. Okay, that is not enough. You have to actually print the name of your corporation above there and put per in front of that. Now the line usually has an X there showing you where to sign. You know where that X comes from? That X comes from ye olde England, when people used to sign using an X. Okay? Isn't that interesting? Anyway, that's how you sign documents. That's how you sign contracts. That's how you sign checks. That's how you sign emails. That's how you sign letters. That's how you sign things in your sleep. Make sure you do that. I had a good corporate client, actually that cutting-edge advertising agency. They had, a corporation for years, and I took it over. Then they wanted to incorporate another company. So I incorporated the company, and then I do my reporting letter. Okay, and I addressed it to Ted. And in there I said, Ted, this is the way that you should set up contracts, invoices, letters, emails, to ensure that there's no personal liability. A couple of years later, he's going to sign a contract for this corporation, and he goes, Peter told me something about how to sign these. I put a line, and under the line I put per, and then I put the name of the corporation. Yeah, perfect. Well, it might not be perfect, but it's close enough. Okay, and so he signed the contract, and then he sent it down to me and asked me if he had done it right. That's not the way to do it, people. Okay, you send it down first, and you ask, if I sign it this way, is that correct? Okay, you don't do it and then say, did I do it right? Because I wrote him back and I said, Ted, all this means is you sign there for the company means I am liable for the company. And he went, oh my God. And nothing happened untoward, thank goodness, but he did it wrong. And he said, but isn't it close enough? And I said, close is only good in horseshoes, grenades, and nuclear war. Okay, the law has to be precise in this regard. Okay, because on screen 83, let's say, that's a different example. But in certain instances, if the corporation doesn't exist, or if you get it correctly, then you would stroke out Peak Performance Pontoons Inc. from above the signature line, and you're not signing per something because that's the wrong company or whatever. So you take off the per. You cannot be an authorized signatory for something that doesn't exist or for the wrong company. And so what's left? Well, Benton counter signature is left, and so bingo, you're personally liable. So you have to remember that. Now, due diligence is outlined in the Section 142 of the BC Business Corporations Act, and it doesn't say by just signing. Okay, due diligence is hiring correctly, doing profit and loss statements so that you know whether you're making money or not, firing employees correctly, supervising, doing quality control if you have a product or a service. It's everything, okay? And I always find it very frustrating in courses where they say, oh, there's a model for due diligence, because there is no model for due diligence. Because it's different for every business. And then the other thing that really frustrates me is they call it corporate governance. Oh, like this is something you just do for a corporation? I don't think so. You do it for a corporation, you do it for your partnership, and you do it for your sole proprietorship, because it's just good business practices. In our partnership, for example, we had a rule that if one of the lawyers drafted a letter and it was going to go out to a client or to the other side in a lawsuit or something, another lawyer had to look at the draft and initial it, so that you had the sort of second kick at the can to make sure there weren't any mistakes in it. So you can have quality control even in a small business. All right, slide 84 talks about the piercing of the corporate veil. Pardon me. This imaginary corporate veil has been chipped away at. Initially, when corporations were formed, they thought it was pretty much like a solid wall. But over the years, the courts have found, and sometimes the legislatures have decided that there are certain circumstances where people should be allowed to pierce the corporate veil to make the directors and officers liable. Now, you've done the chapter on torts, and when I got to the tort of negligence, I talked about the Reynolds versus Clark case, where the courts first decided that there was this thing called negligence. And the judge in that case was very careful. He said, "Oh, we're not going to make everybody responsible for everything. We just cannot do that. There's things called unavoidable accidents." And so he said, "Okay, in order to be responsible for negligence, you have to owe the defendant. The defendant has to owe the plaintiff a duty of care. The defendant has to breach that duty of care, and the defendant has to cause the plaintiff's injury." When a judge decided that, okay, the corporate veil should be allowed to be pierced, I don't want to say in every circumstance. And so he equated it to negligence, and he said, okay, so three things are required, and that's set out on slide 84. First, the individual must be in a position of control, sort of like the defendant in negligence, right? But not total control. It must mean has operational authority for the company in some regard, okay? And the control must have been used inappropriately, okay, like negligence, okay? And so he said to commit a wrong or a breach of a duty. There was a third thing too, and I can't see my screen here. So a wrong. Oh, you can't do it to commit a fraud or wrong or a breach of duty. And then the action must be what caused the loss of the person that wants to pierce the corporate veil. So let's say I embezzle money from my company, a little bit each year, and then there's a negligent manufacturer of goods, and the company gets sued, and it's everybody loses their money. Somebody that sues might say, "Aha, you committed a fraud. You embezzled money. so I should be able to pierce the corporate veil and go after you for the loss of the company. No. Okay, I'll get charged with a crime of fraud maybe, but you won't get to sue me because my fraud did not cause your loss. Okay? And so this was designed, you'd have other remedies. Okay, you could go after them for, whatever, but not, you couldn't pierce the corporate veil and make the directors and officers responsible. Okay? The idea is it's like negligence. The defendant might injure you. Pardon me, the defendant might be negligent, but maybe his negligent actions didn't injure you. Okay, so what the judge was doing was saying, okay, we're going to pierce the corporate veil, but we're going to make sure it isn't just like a blanket disruption of corporations, because people would stop investing and there'd be an economic collapse. So that's the rule. And then on slide 85, I have listed all the ways books talk about corporate veil being pierced. And originally I think I had something like 7 of these years ago. And then over the years I kept adding more and more as judges found other circumstances when people should be responsible for the debts and obligations of the corporation. And then I looked at them, and they talk about piercing the corporate veil, but sometimes the courts don't pierce the corporate veil so much as doing an end run around it. They're not going through the corporation to get at you. They're actually going at you indirectly. And so I've got it piercing the corporate veil and circumventing the corporate veil. And where are we here? Okay. I'm just going to check and see how much we've got a lot to do on this, and I think what I'm going to do is stop here and pick it up in a few moments, because I've been going at it for quite a while. I feel my throat getting a little scratchy, and I'm looking out the window, and I do have to mow the lawn. So I'm going to mow the lawn and then come back and we'll finish this off. Okay, thank you very much.